Namaste. The LIC pension updation appeal of December 3rd, 2025 at the Supreme Court on has come and gone. And if you've been following the LIC and AIIP updation case as closely as the MC Singla case, you know just how critical the fight for pension parity has become for millions of retirees and super seniors. I'm Priya Chakraborty and my co-host is Nisha Bhattacharya.
Absolutely. When most of us think about the Supreme Court, we picture these grand moments, right? Landmark judgments, huge constitutional questions settled, the final word on the law. But what often goes completely unseen is the real engine of justice, which is, the procedural battle, the fight just to get your case heard in the first place.
And that's exactly where we're going today. We are peeling back the curtain on the December 3rd Supreme Court appeal hearing between the DFS and LIC Pensioners Union, AIIPA. We're looking at a very specific and very strategic, complex intersection of finance, fairness, and justice in the highest court in India.
In today's podcast, we are carrying out a deep analysis of a recent and very sudden roadblock in the LIC pension updation fight. We're talking about the sudden and unexpected adjournment of a huge Supreme Court hearing, LIC DFS versus AIIPA, Civil Appeal number 3465 of 2024.
Today, we're taking a deep dive into a recent and very sudden roadblock in that fight. We're unpacking the sources that detail the unexpected adjournment of a huge Supreme Court hearing, LIC DFS versus AIIPA, Civil Appeal number 3465 of 2024.
And this is not just some, dry court procedure. Our sources here, from the really emotional circular issued by the Pensioners Association AIIPA to the more recent court analysis, they put us right at this friction point in Indian justice.
What's a friction point?
It's the human cost of due process versus the profound suspicion of administrative sabotage.
Okay,
we have to synthesize these two radically different takes on what happened.
That's our mission then, to understand why a hearing that everyone thought would bring a resolution on December 3rd, 2025 to LIC pension updation fight was just abruptly postponed.
Right?
So keep this date in your head. The new hearing is now set for February 4th, 2026. That 2-month gap holds all the drama, the procedure, and the massive financial stakes we're about to get into. Let's jump in.
Let's do it.
So we have to start with the perspective of the petitioners, right? The All India Insurance Pensioners Association, or AIIPA. We have their circular from the day after, December 4th, 2025.
And it just reads like a document it's vibrating with frustration and disbelief.
It really does. It captures that moment of, maximum readiness meeting, maximum disappointment. AIIPA, the LIC Retirees Union, felt they'd done everything right, and then this.
Stopped by something, an invisible force they couldn't see.
Exactly. Their preparation was exhaustive.
Mm-hmm.
The nodal advocate for AIIPA put in a ton of work and had spent weeks on what was called a Herculean job.
Mm-hmm. Coordinating with all the main counsels, the advocates on records.
And those are the main attorneys who actually file the case documents for anyone unfamiliar.
Exactly, for all parties involved, and that intense coordination resulted in a monumental task.
Tell us about the paperwork.
Get this, they recompiled all the necessary documents for the bench. The revised compilation runs into 6 volumes.
6
volumes containing around 4,000 pages. That level of work, it just underscores how much they expected the arguments to start and maybe even finish that day.
So you can just imagine the shock when the Supreme Court bench, without any request from the government or the petitioners,
a suo motu action.
Entirely on its own motion, announces the adjournment. They granted a 2-month delay until February 4th without what the pensioners saw as any valid reason at all.
And what's so fascinating is how much that flies in the face of current judicial climate.
How so?
Our sources point out that this specific bench had been consistently telling the respondents no more adjournments. An even bigger picture, it contradicted the new Chief Justice's guideline for quick disposal of cases, which literally said no adjournment to be granted.
So that's stark contradiction. The bench says no delays, then suddenly creates a 2-month delay. That's what's fueling all this cry of injustice, and justice delayed is justice denied.
Absolutely. The circular says it flat out. The feeling among petitioners was that some invisible forces interfered in our matter. They even invoked that old saying, in love and war, everything is fair, which really frames this as a battle for them.
A battle against administrative headwinds and foot dragging.
Mm-hmm. And when a delay is that surprising, the follow-up becomes suspicious. We see that the AIIPA General Secretary, S.K. Awasthi, went straight to the Department of Financial Services, the DFS.
Which is the government's regulatory arm for LIC.
Right? He met with an undersecretary, a Mr. Abdul Ghufran, and what did Ghufran say? He confirmed their letter was on file, but that nothing worthwhile had come of it.
So,
Nothing, pretty much. And then, importantly, he says the matter needed a vigorous and effective follow-up by LIC authorities.
so he's bouncing it back to LIC.
Exactly. To a desperate retiree, that looks an awful lot like deliberate friction, like passing the buck to deliberately cause a delay.
So that sense of friction leads us, I think, to the technical heart of this. Before we get to the court side of things, let's be really clear on what this case is actually about. What's the specific financial demand here?
So the parties are on one side the Life Insurance Corporation of India, LIC, and the Department of Financial Services, or DFS. And they're up against the All India Insurance Pensioners Association, AIIPA.
And the central issue is,
It's pension updation and parity for these insurance retirees.
okay, let's spend a minute on a pension updation. For you listening, why is updation a much bigger and costlier financial burden than, say, a simple pension revision?
This is where the financial stakes just explode. A pension revision is usually just, an increase based on inflation. It's a controlled adjustment, is totally different. The petitioners are arguing for their pension to be tied to the current pay scale of someone holding their old job today.
Wow. So if an official retired 20 years ago, their pension gets recalculated based on the much higher 2025 salary for that same job?
Precisely. That is a massive immediate jump in financial liability according to LIC and DFS.
And that's why the government side is fighting pension updation so hard.
On every fiscal and actuarial ground they can find. And they're basing this whole demand on a precedent, right?
Yes, and this is strategically critical. They're demanding parity with the outcome of the MC Singla litigation.
That old chestnut again for banking sector retirees, a case coming up this Wednesday, the 10 in court number 2.
Specifically, Reserve Bank of India retirees. That precedent is everything. If the Supreme Court grants this to LIC retirees, it strengthens the legal hand of, every other nationalized financial sector employee. It could impact hundreds of thousands of people.
So the LIC case is completely intertwined with the Singla matter. A ruling here would create a huge fiscal ripple effect.
Now, let's just quickly identify the judges who was on the bench making this call.
The bench consisted of Hon'ble Mr. Justice J.K. Maheshwari and Hon'ble Mr. Justice V.J. Bishnoi. And knowing that is important because they are known for procedural rigor. They want finality, but they are not gonna sacrifice due process.
Especially not when public funds of this magnitude are on the line. Okay, so the stakes are immense. We get that. But hold on, for every emotional argument, every suspicion of invisible forces, there's a procedural requirement. What was the court's side of this? Let's shift to that counter narrative.
And that counter narrative offers some very clear procedural and fiscal reasons that push back hard on that invisible forces theory. The core reality is the adjournment wasn't arbitrary.
So it wasn't suo motu.
It was driven primarily by a prayer, a request made by the Council for the Union of India and LIC.
Wait a minute. If the government had months to prepare and the petitioners had already compiled those 4,000 pages, why wait until the day of the hearing to ask for 2 more months? I mean, that looks exactly like a calculated delaying tactic.
And that's the conflict, isn't it? That's why the suspicion is so strong that this was yet another unjustified delay. But the legal defense, the reason the court granted it, rests on the bedrock principle of natural justice.
The right to be heard.
Audi Altaram Partham. The government's argument was they couldn't possibly prepare their detailed financial rebuttal until they had time to actually digest all the new calculations in that massive 4,000-page document.
So the court had to choose speed of relief for the retirees versus legal fairness for the government side.
Yes. When public funds are involved, natural justice demands that the government gets a full and fair opportunity to put its complex fiscal defense on the record. Without that, any ruling would just be vulnerable to a legal challenge later on.
And that brings us to the second reason, which moves beyond procedure into, well, financial accountability.
That's right, the issue of actuarial and economic complexity. This isn't just about interpreting some pension rules, it's a matter of economic law and actuarial calculus. Meaning the court cannot issue something as powerful as a writ of mandamus, which is a directive to act if it involves a massive financial outlay from the public purse without concrete verified data. They needed validated economic figures.
They need proof that the institution can actually afford to pay it without going under.
Precisely. They required specific data on the liquidity and solvency ratios of the LIC corpus. So the adjournment, from this perspective, gives them time to submit that technical financial data. It reframes the delay as an essential step for a fiscally responsible decision.
Okay, that helps explain the why of the 2 months. It starts to feel less arbitrary. But why February 4th specifically? Why not, say, mid-January?
Calendar logistics, plain and simple. The Supreme Court has its winter recess in late December. When it reopens in January, there is a predictable massive deluge of fresh matters.
A judicial traffic jam.
Exactly. So setting the date for February 4th, 2026, a Wednesday, which is a key day for these hearings, moves the case past that initial rush. And making it a fixed date hearing is also hugely significant.
Absolutely.
It's a signal from the bench.
Really?
Yes. The date says, we are prioritizing this. We intend to hear substantial arguments and not allow more indefinite delays. It's a commitment to disposal.
So when we put these two narratives side by side, what does it all mean? We have the pensioners' sense of betrayal and trepidation, this belief in interference.
Contrasting with the court's very real need for due process, financial prudence, and just simple calendar logistics.
So what's the synthesis here?
The crucial takeaway is probably this. The adjournment was a procedural rescheduling, a deeply frustrating one that compounds the delay for retirees, but a necessary one from the court's view, driven by the government's filing and the need for substantive, verifiable actuarial data.
And the human cost is real. Let's not forget thousands of retirees on meager pensions. Those 4,000 pages, the Confidence Council felt, it just underscores the frustration when the hearing doesn't happen. It's a psychological drain.
It's a setback in time. But the hope is that it's a move toward judicial thoroughness. And the strategic hope for the pensioners remains that this case will ultimately be heard alongside or at least in coordination with the Singla matter.
To avoid fragmented rulings.
Yes, fragmented rulings on the exact same pension issue would just create legal chaos. The bench needs to create a coherent judicial approach for the whole sector.
This is such a textbook example of that friction between the ideal speed of justice and the rigorous, sometimes slow requirements of due process.
Especially with billions in public funds on the line, although some retirees deny this, saying their corpus can fund updation.
So you are now fully informed. You know the procedural, emotional, and fiscal complexities behind that December 3rd adjournment. You understand the shock of AIIPA, that massive compilation of documents, and the counter-arguments based on justice and logistics. The fate of this appeal now rests on that February 4th, 2026 fixed date hearing.
And here is a final provocative thought for you to consider as you wait for that date. Given the court's absolute requirement for concrete data on the liquidity and solvency ratios before it can act, how effectively do you think the government's affidavit will manage to balance natural justice for these senior petitioners who are understandably desperate?
Big question. Is there a judicial path that can actually serve both masters at the same time?
That tension, fairness versus financial feasibility is what we'll be watching for next February. Thank you for joining us today. Please like, comment, share with friends, and subscribe.